yangu sio kusema. Hilo la kwanza. La pili, ni bahati iliyoje kwamba miongoni mwa watakaowasilisha mada ni wagombea wa nafasi ya urais wa chama. Wagombea hawa pamoja na kwamba tunawafahamu, lakini sio baya nikatoa fursa hii ya upendeleo, angalau wakasimama nikitaka kimtaja au kumgie mkono mjue huyu ni nani. Nianze na Daktari Edward Osea. Nimemuona. Flaviana Charles. Nimemuona. Shezada Wali. Nimemuona. Albert Mzangu. Nimemuona. Sasa mimi ni mmoja wapo katika watu wanaogombea nafasi ya urais. Wakati napewa nafasi hii, nani nimemsahau? Nilisema tu wagombea kwanza. Naheshimu watu wa mada, tutakuwa na jaji mstaafu Dr. Paul Swaibu na Mheshimiwa Balozi Manja. Na wewe unagombea kwenye urais. Jamani, tunagombea wasita kumbe kwenye urais. Sasa wakati napewa jukumu hili, nikasema nitaonekana kama nafanya haki nikiongoza jopo hili, hasa wagombea wenzangu. Sasa nikakumbuka maneno ambayo aliyazungumza jaji mstaafu wa mahakama ya rufaa Robert Kisanga, ambaye wakili mmoja alimwambia kwa Kiingereza, as you know your lordship, you cannot let a monkey judge forest affairs. Sasa jaji yule akamwambia, wale wanaomfahamu walikuwa wanaongea yeye taratibu, akamwambia not necessarily, because a benevolent monkey can fairly judge forest affairs. Kwa hiyo nyani yule akiwa benevolent atahukumu kwa haki kesi za msituni. Sasa nilipo yakumbuka maneno hayo, nikaona let me now be a benevolent monkey to judge these affairs. Baada ya kusema hayo, sasa bila kupoteza muda, naomba nimkaribishe wakili msomi Harold Sungusia. Lakini kabla hujaanza kusema maneno hayo, kwa mamlaka niliyo nayo katika mikono yangu na katiba yetu ambayo ni ratiba, ninayo mamlaka ya kurekebisha. Na nimerekebisha badala ya dakika 20 kila mtu, basi nawaomba mtumie dakika 10, kwa sababu tumeshatumia muda mwingine ambao hatuwezi kurudisha. Sasa baada ya kusema maneno hayo, naomba wakili Harold Sungusia, shika nafasi yako dakika 10. Hivi sasa ni 12:32. Kwa 12:42 wewe unamaliza. Karibu sana.
Mheshimiwa Rais wa chama chetu cha mawakili, Mheshimiwa majaji wastaafu na Mheshimiwa wote mawakili wenzangu mliokuwepo hapa pamoja na wageni waalikwa. Nimepewa fursa dakika 10. Nina presentation yangu fupi. Nitajitahidi sana nisipresent kila kitu katika hiyo PowerPoint, lakini niweze kusema machache, alafu hiyo PowerPoint presentation bila shaka secretariat watatusaidia tuweze kupata yale mengine ambayo singeweza kuyazungumza kwa muda huo dakika 10. I'm required to share with you a very brief presentation about the recent developments and the future of the legal, in fact, the recent legal developments and the future of the legal profession. Allow me to control myself. I will control the slides myself, okay, because I'm going to skip a number of them. I think it works. Okay, fine, perfect. Well, according to the terms of reference, I decided to narrow down this presentation in a manner that I will be able to just focus on what can be available and what can be shared within this short period of time. To start with, The word recent, I just defined it to mean that the period between, for the purpose of this presentation, the period between January 2016 and March 2021. Legal development in this presentation means, among other things, the amendments or enactments that were made in this period. And the future means any period after today. And the legal profession, I tried to narrow it down, making sure that I'm not talking about everybody else in the legal profession, but I narrowed it down to mean the practicing private advocates under the Advocates Act. Having said so, three things that I want to share with you. In terms of legal development, there are some number of references that you can refer to a time when you get this handout. But I will simply go straight to present to you the developments that happened in terms of legislation in this country since January 2016. And the point of reference is the website of the Parliament of the United Republic of Tanzania. And here, these are statistics that we were able to garner from the website, and are telling us that since January 2016 to December 2020, they were enacted, the legislation that generally were passed, pieces of legislation, these are 59. Ordinary enactments are 38. Miscellaneous amendments are 21. And in those miscellaneous amendments, 166 different legislation were enacted, were kind of amended, either being repealing or replacing or introducing new sections thereinto. So this is just the statistics. This is just a statistics that are showing that for this period of 5 years, there have been a lot that has been happening in terms of legislating. And we were also able to go further into those amendments that were done. 166 amendments, we were able to scrutinize those amendments. If I can also share with you the trends from 2016 to 2020, you could see that at least in 2020, that is when we got the least number of amendments or enactments. But in 2017, that is the year when we got the highest number of enactments and amendments in the country. What are these amendments and enactments mean to lawyers and to the legal profession? We were able to highlight some of those issues that were brought forward by number of enactments or amendments. And there are some common denominators that you can find amongst most of the amendments that were done or the enactments. And this is the question that we are asking ourselves. All of these laws, what do they really mean to us as legal practitioners? Are they encouraging us to practice further and to discharge our mandate and duties as practitioners? Or are they impediments towards our practitioner? Are they causing kind of hurdles and clogs to our practice? Now from there, I just listed in my presentation number of all of those amendments and enactments that were done in all of those years up to 2020, from 2016. And I've decided to highlight some salient case studies therefrom. One of the things that came up very clearly,
3 minutes left.
yes, I'm finalizing. From that particular, what is happening with the presentation? From that particular, the PowerPoint is off, but I can still proceed. Things that were very salient from these enactments and amendments are the following in terms of our legal profession. Number one, the amendments that were done, for instance, to the Attorney General Discharge of Duties Act and to the Advocates Act, somehow removing or exempting some advocates from the, some legal practitioners from the Advocates Act. Something new that was introduced in this period was the plea bargaining. Another thing that you also noted, the re-establishment of the office of the Solicitor General. We also saw strengthening of the practice of compounding offenses. We also saw the redefining of the serious offenses, enhancement of forfeiture of property, restrictions to law officers to practice law as advocates. We also saw the introduction of the principle of overriding objective that was very clear, that amended the Appellate Jurisdiction Act and the CPC. We also saw the restriction, the restriction that was meant to restrict partisanship or partisan leadership in the Bar Association. And we also saw introduction of serious bottlenecks to our core legislation that is guiding the practice of lawyers. That includes, among other things, introduction, for instance, of the annual general meeting of members and the election of the leadership of this bar society by way of representation. We also saw, with this introduction of some bottlenecks and clogs in our laws that are governing our practice, establishment of the statutory position of the head of the management of our society. That now, 1 minute, the head of management is not just there as an employee of the society, but now as an establishment. The office is by establishment of the law. Another thing is non-adherence, serious non-adherence. I was reading these United Nations basic principles on the role of lawyers, and there's serious non-adherence to the principles that we are supposed to guarantee independence of the bar society. We also saw from these enactments and amendments a number of practices in relation to anti-money laundering, including the practice of enforcing the regulations that were enacted in 2012. We also saw limitation of public interest litigation through the amendment of the Basic Rights and Duties Enforcement Act. We are now also seeing serious insulation of the government or the public sector and its agencies against any potential or legitimate claim that may emanate from the people. You can now see the immunity of the president, immunity of the member of parliament, like the speaker and the deputy speaker, immunity of the chief justice, and immunity of several officers also coming into play, including the judicial officers. We're also seeing insulation of the government agencies, that now any government agents, you cannot just sue it, you must follow the Government Proceedings Act in order to do it. And when you are successful, you also meant to follow the advocate.
Needs to be concluding now.
Yeah, I'm concluding.
Yes, concluded.
Yes, so this kind of insulation is one of the very, very underlying characteristics of what we found from these amendments. So, use of ICT in the legal profession is something which is very positive, including filing of cases, including handling cases online, and also we are seeing a number of laws that were enacted or were imposed that were curtailing basic freedoms of individuals. Now, having seen that, maybe let me conclude. What is this all telling us? In 1 minute, Mr. Chairman, with your permission.
Granted, 1 minute.
Yes. What is this telling us in terms of the future of our legal profession? 3 things. One, that we are now witnessing invoking of the extraterritorial jurisdiction in seeking remedies, including filing cases at the East African Court of Justice, and also the trend that was just curtailed by withdrawing that declaration under Article 34.6 of the Court of that is establishing the African Court. Number 2, the challenge that is brought by the demography is also a challenge and creating a dilemma.
And this is one thing that we should also put in consideration in terms of our future, of our practice. How are we going to manage the ever-growing number of members without curtailing their rights and their duties, or in affecting their mandate to discharge what we are supposed to be discharging according to Mr. Chairman, thank you for your time. Okay, thank you. Much of this is available in my presentation. Exactly. I'm sorry that the time was not enough. Okay, join hands together for Harold's Thank you, Harold, for that good presentation. Well, I know that it's very attractive, but we cannot extend further our time because we have a lot of events. So after that one, I would like to take this opportunity to invite the learned counsel, Mr. Albert Nsando, to make his presentation. Then I'll invite the third one, then we will have a short break for our sponsors. Karibu Harold, nami Albert Nsando. Thank you very much, Mr. Chairman. I'll just go straight to my presentation because I see time is the challenge here. I'm supposed to present on challenges and opportunities in recent legal development that affect legal profession in Tanzania, and I should lend my appreciation to my fellow brother Harold for his presentation, which has laid the foundation of what my presentation is about. Unfortunately, we did not be able to exchange notes so that I don't become repetitive. But otherwise, when I was given this topic, I just had to think of a concept which I'll share with you, which is commercial awareness for lawyers in respect of the recent legal developments. Commercial awareness, as you want to know, is it's an understanding of the world around you, your clients, and everybody else who you are trying to serve. What is happening? That is what we are looking at. What has developed legally, and Harold has highlighted those areas. The very first important thing that I looked at, individually and collectively as lawyers, how do these recent legal developments affect us? That's the key question that we should be asking ourselves. And in the very when I was listening to our guest of honor, without being disrespectful, it got me thinking, and then I went back to what Ivan Karalov wrote in 1769 when he wrote his famous poet, The Inquisitive Man. This is when the question of the elephant in the room came about as a concept. That somebody is busy going to a museum and notices all sorts of tiny things, but cannot notice the elephant in the room. Recent legal developments highlights the elephant in the room. It's very easy to blame the advocates, but it's very hard for the state to take responsibility of the developments which have a direct impact on the advocates. And I'll highlight few so that when we go out there, we look for more and see how we personally are affected and collectively are affected. Harold has said about restrictive laws. Now, I'll talk about two acts, the amendments. One is the now proposed amendment to the Advocates Act. Introduction of the Regional Advocates Ethics Committee. As you're all aware, the members are the Registrar of the High Court, the State Attorney in charge, or the Deputy Officer of the region, and the Chairperson of Chapter Convener of TLS in the region, and the Secretary is any public servant who may be appointed. The quorum for the committee is two can make a decision, whereas one of them must be the State Attorney in charge. Their powers include determining application for the removal of your name from the roll. Their mandate is to hear and determine any allegation of misconduct against any advocate brought about by any person. Underline the word any person. Any person can make a complaint against you. The Regional Advocates Ethics Committee can sit as long as there are 2 members, State Attorney being one of those, or Deputy Prosecution Officer, and determine your fate. Between advocates and the state attorneys are daily. The relationship is antagonistic. We don't love each other that much. So if you have issues with the state attorney in your region and they decide to earmark you as one of those people who they are not happy with, then let's see how impartial that body can be against the advocates. Now this goes back to what I will try to address. The intention of the government to amend these laws. Harold has mentioned all of them. To highlight the ill will, the bad motive for amendment. We withdrew from the African Court our declaration, correct? That an individual cannot access that court. At the same time, we amended the Bradea, that the person to bring an action must be personally affected by that action so that to bring a petition. So my brothers, for misconduct by an advocate, any person can go to the committee. For violation of human rights which are inviolable, which are grave, the government restricts who can take an action. So if you have a good intention for access, why do you limit suits against the government, which are more grave, to only be brought by those who are affected? But actions against advocates can be brought by even an affected person. If you're in a bar, you get into an argument, any bar, like even the Don. If you are there and somebody next to you is unhappy and says this is a misconduct, he can go to the committee and complain. Any person, I'm not affected, the misconduct does not concern me, I don't like this advocate. You'll be running every now and then dealing with allegations of misconduct while practicing. Because any person can break that, anyone. That is the effect I could highlight.
3 minutes, Albert.
The other law, which I will highlight, is the anti-money laundering. Everybody gets chilling when you hear that act. That law provides we are reporting persons for any suspicious transaction, And being a reporting person as an advocate, when you form suspicion, within 24 hours, you must report to the Financial Intelligence Unit. You must report. Non-reporting is punishable. Fine 5 million, imprisonment not exceeding 5 years. Now, ask yourself, you have received a document from a client, you suspect it's forged, you have to report. You have received a transaction, you feel it's illegal, you have to report. Who will give work to a snitching advocate? Who will give that work? Because they know if I go to Stoller, he suspects me even if it's not true. He reports me to financial unit. That's a challenge. But there are so many other challenges that we face, including us being arbitrarily detained when you are doing your duties. We are all witnesses of that. I don't need to be reminding you. And that's violation by state agents. The challenge we have, the global pandemic. Unfortunately, the biggest challenge is we don't have data. There's not any scientific research that has been done to show how COVID-19 has affected the legal profession. There is no data anywhere. And we cannot tell how lawyers are surviving. I know most of us tulikuwa ICU. And how we have passed, how we survived today, God knows. The big firms have been heavily affected because their big clients have been struck with COVID. Nobody is bringing foreign investment here. It's a challenge for lawyers. How do we move forward? Now, the other challenge is what I've called the enemy within. We are our own enemies. The drafters of the lawyers are lawyers. The judiciary is there. These laws are there.
Why are we not getting rid of them? The judiciary has those powers, but they don't assist us. But they'll tell us, we're opening up doors, come work with us, but you pass those laws. If you want to cooperate, be honest. Let's open a new chapter. Hear us. We'll advise you properly, because that is the work as lawyers. 10,000 lawyers cannot fail to advise. They can't. And the only interest we have is to advise. So what are the opportunities? We have the Arbitration Act. Let us encourage the young lawyers to take interest in arbitration, because it's a speedier means of resolving disputes.
Time
we have the
expired, but
digitization.
One more time. 1 minute.
1 minute.
Yes.
Okay. Digitization of the court system. Now, we should have our matters speedily dealt with. All those physical processes, like saving documents, seeking adjournments, let's use technology and do that, even though it's too prompt, because technology also has made it simple for human resource officers to have templates. They don't need you anymore. They just go online and then they have a template for their contracts. And then you have the cross-border legal practice that we should use. But again, the last one, Mr. Chairman, is a matter of fate as an opportunity. A matter of fate is, we have a new head of state. The one before is gone. So whenever there is a change of head of state, it's an opportunity to open up new doors, to heal wounds, and to work together. We have heard pronouncements by the new president, encouraging foreign investment, talking about work permits. Let us use that opportunity as advocates, so that we can now take back our practice in place. Let us not get into antagonism at this early stage, if there is an opportunity to do so. Wanasema kwamba kama anaweza kufa kwa asali, kwa nini umpe sumu? If we can take that opportunity and see how we make our practices turn around, that will be very good. And lastly, let us rethink our model of our association. How can we be strong? We have the chapters. Let's empower chapters. Let's make chapters as powerful as us and see what will happen in those regions. Let chapters be able to own properties. Let chapters have their own secretariats. Let chapters make their own decisions. When we are strong as a body, these laws, we can object against them. We can work in unison. One day we can all say, we are putting down our ropes, we are not going to court, change the laws. If not, defend yourself, we'll be normal citizens. Thank you very much for listening.
Thank you, Council Albert Msando, for that passionate and insightful presentation. It is time now to invite another presenter, Flaviana Charles, Learned Counsel. Are you ready for presentation? Take the podium. Karibu.
Thank you so much, Mr. Chairperson. Learned brothers and sisters, because of time, I'll just go straight to the point. And when you look at my presentation, you'll understand that I started with the introduction by talking, explaining a little bit about what is about the legal profession in Tanzania and the way it's division. But I went forward on talking about the private bar. What is it? And we know that because we are inside that. And I went further again and spoke about the public bar. And my title actually, it will recognize all types of members. And it should be noted that what unites us between private practitioner and public practitioner is not the function of lawyering. It is a law. The word law is the one which unites us. The word law. Tanganyika Law Society. The word law is the one which unites us, and it makes us together. And that's why we have a single bar association. And this was a spirit of the Tanganyika Law Society Act of 1954 and the Advocate Act, it was created in 1954. It presupposes that we're going to have the same single bar association for both of lawyers. Now, before I go further, and that's why you find the judges and other people, they're happy and proud to be part of us because they belong to us. They are ours. And that's why we need to fight and make sure that we get united. Okay? Okay? So, now, how do we consolidate our unit after seeing what happened? Why we have this kind of division? Number one, I've put some few points, and some of them you're going to see in my presentation. I've put in the presentation.
4 minutes?
Yes, 4 minutes. I'm going to show consolidating the units among the lawyers. Number one, I think we still have a chance. Number one is to conduct some lobbying with the Office of Attorney General in order to have a single leadership or a single of lawyers, that is a single bar association. But number two, we need to resume the annual general meeting that previous was held in Arusha, like now we are sitting together and discussing different issues together. But also we need to provide a forum for discussion in matters of issues, especially on the issues of common interest among the members, regardless to the division we're having. But also to further study and understand the development of public legal service through continuing legal education, training, and other avenues. But we still have a chance to learn the best practice of Kenya and other countries which have a single bar association with a single leadership. So I pray that if we agree that we go through a lobbying process so that we can reform, we can call upon the unit again by working upon the law which has been enacted. I humbly submit, but we can further discuss, and there's a lot of information in my presentation, but I want to keep it time. Thank you so much for listening.
Meetings, those days of the East African Law Society, our friends in other countries used to ask us, when Kenyans are asked, what is the National Bar Association? They say Law Society of Kenya. Uganda, ULS, Uganda Law Society. Rwanda, Rwanda Bar Association. But when it comes to Tanzania, because we are both there, the TLS and ZLS, then we start looking at each other. Which one should form the National Bar Association? That is the unique configuration the Madam Vice President was talking about. Without any further ado, let me take this opportunity also to invite another presenter. This is nobody than Dr. Edward Osea, Learned Counsel. Please take the podium.
Mr. Chair, because I wear glasses, and if I want to see the slide so that I can start talking, if you penalize me, then I cannot be within 10 minutes.
I will grant you one more time in advance.
So my paper is on the challenges of the legal practice in relation to financial crimes law. Next slide. Skip. Or should I use this? Okay. As I said, in my eyes, I use glasses, and if you allow me, let me go closer to the screen so that I can do justice to my presentation.
Yes, please do.
Is that the microphone? The problem of the screen is not enlarged.
We have the mobile microphone, Secretariat.
So, to kickstart the presentation, I'm going to use a comparative study that will show how lawyers in Tanzania, how the legal profession in Tanzania are curtailed by the financial crimes legislation. I'll pick a simple example, the relationship between advocates and their clients, the issue of confidentiality. According to the relationship between the advocates and the clients, it's supposed to be confidential. But like other speakers have already alluded to, in Tanzania, the challenge is grave because you cannot keep secret, you cannot keep confidential any information that you receive from your client. The law obliges you to report it to financial intelligence unit. Therefore, in Tanzania, clients may be suspicious if they learn that if I go to my lawyer, he's going to be a snitch, he's going to report to the financial intelligence unit. Now, in a Canadian context, I have some case law which shows how this kind of law was interpreted by the court. The court went further to argue, or to lay the foundation, that in Canada, the bar must remain independent. In order for the bar to remain independent, you need to maintain the client attorney relationship, and therefore the court found in favor of the Canadian Bar Association that they are entitled to maintain the confidentiality between their client and an attorney or an advocate. So if we go to our laws, one of the laws which are inroad to this kind of relationship between the advocate and the client, in particular, and my colleagues have already alluded to, the anti-money laundering laws. The anti-money laundering laws are part of the financial crimes legislation. And because you are required to report any suspicious transaction, you have no choice other than reporting to the Financial Intelligence Unit, the failure of which you'll be held accountable. I'll skip most of the issues because I understand I have limited time. Now, under the money laundering offenses, what is the mens rea? What is the intention under the money laundering offenses? There are two elements. There are two elements to establish mens rea under anti-money laundering law. The first is intent to conceal or convert a property or proceed of property. Two, knowledge or belief that the property or procedure derived from an enterprise, crime, offense, or designated substance offenses. Therefore, if you're handling a financial crime-related offense client, you are supposed to go to the financial intelligence and report to the financial intelligence that my client is involved in money laundering. So what is the important point am I trying to make it here? Under the anti-money laundering electronic funds transfer and the cash transaction reporting regulations of 2019 that was published by Government Notice number 420 on 24th of May 2019, it gives an obligation of reporting persons that every reporting person shall report the following transaction to the Financial Intelligence Unit. A currency or transaction involving Tanzanian shillings or any foreign currency equivalent of $10,000 or more. Two, an electronic funds transfer involving Tanzanian shillings or any foreign currency equivalent of 1,000 United States dollar or more in the course of a single transaction. So lawyers are required, A, to report any transaction, a single transaction of equivalent to US dollars $10,000. Two, they have also to report any transaction of $1,000 or equivalent of Tanzanian shillings to the Financial Intelligence Unit. Now the question is, how many reports are you going to report? For example, 1,000 equivalent to T shillings. You know how much is T shillings? It means every transaction equivalent to $1,000, you have to report to the Financial Intelligence Unit. It's an onerous requirement. And I'm wondering to what extent the Financial Intelligence Unit is going to keep this pile of reports and they work on those reports and they distribute to the law enforcement agency. Now, in conclusion, because of time factor, if you don't report under the first schedule of economic offenses, in particular Section 4, subsection 1, it imposes punishment. And what is the punishment? If you knowingly furnishes advice or assistance or direction in the conduct of financing or execution or management of the business or affairs, you are liable to that to conviction, and the conviction is the minimum. The minimum is 20 years imprisonment or 30 years imprisonment. Now, in the other jurisdiction, I'm concluding Mr. Chair, I'm concluding my point. In other jurisdictions, like the Canadian situation, this is what the court decided in the context of what we are talking about. In the case of Andrew Law Society of British Columbia, of the case of 1989, McIntyre judge put it this way: self-regulating is certainly the means by which we have chosen to protect the independence of the bar. In the absence of an independent legal profession, skilled and qualified to play its part in the administration of justice and the judicial process, the whole legal system would be in a perilous state. In other words, the laws that legislated, if they go to the root of the independence of the bar, it means clans reporting to the Financial Intelligence Unit. No one can come to us because we are snitches, like my brother Msando put it. Now, in conclusion, this is my conclusion. Number one, the role of the legal profession in the financial crimes is set out by the anti-money laundering regulations as administered by the Financial Intelligence Unit. The legal profession has a role to balance the delicate balance between our clients' confidentiality on the one hand, and our obligation to report to any suspicious transaction pertaining to any financial crimes to Financial Intelligence Unit. Therefore, the reasonable and the well-informed client would see his or her lawyer being required by the state to collect and retain information that, in the view of the legal profession, is not required for effective and ethical representation, and which respect there are inadequate protection for solicitor client privilege. Clients would thus reasonably perceive that lawyers were at least in part acting on behalf of the state, collecting information, retaining information, and in the circumstances which the privileged information might well be disclosed on an acceptable degree in which the lawyer's ability to provide a committed representation is undermined. I conclude by saying we have the duty to engage, as the Deputy Permanent Secretary said, we have the duty to engage the government to see to it there are certain provisions in the financial crimes legislation which are inroads to the stability and the independent bar. Mr. Chairman, thank you.
Thank you very much for that eloquent and beneficial presentation from you. So on behalf of the entire membership, I thank you very much for that presentation. Before we proceed with other presenters, let me invite the Secretariat to have a word or two. Lowe.
Asante sana Mr. Chair. Tutaomba muda kidogo turudi kwa sponsors wetu kwa matangazo mafupi, alafu tutaendelea na presentation zako Mr. Chair. Kwa kwanza naomba ni waalike Legal Services Facility RSF. Please, 5 minutes. Alafu Ngorongoro Conservation na wajiandae for 5 minutes.
Asante. Rais wa Chama cha Mawakili Tanganyika, majaji walioko hapa, lakini wagombea wa nafasi mbalimbali na mawakili wenzangu, habari za mchana. Naitwa Deo Bwire, ni wakili, ninafanya kazi katika shirika inaitwa Legal Services Facility kama mkurugenzi wa program au director of programs. Mawakili wenzangu, kama tunavyofahamu, changamoto nyingi za upatikanaji wa haki nchini zimetokana na sababu ya mifumo ambayo ina changamoto ya upatikanaji wa haki, kuanzia mfumo wa haki jinai na mifumo mingine ya haki za binafsi, hata kiuchumi, lakini pia na haki za kijamii. Legal Services Facility imekuwa ikifanya kazi katika programu ya upatikanaji wa haki, na kwa miaka 10 sasa tangu imeanzishwa, Legal Services Facility imekuwa msaada mkubwa sana katika kusaidia upatikanaji wa haki nchini
kwa mfumo wake, kwa programu yake ya Access to Justice kwa watu wote, lakini hususan kwa wanawake na watoto. Tumekuwa tukifanya kazi na wadau mbalimbali, lakini kwa miaka 10 iliyopita tulifocus sana katika mfumo wa traditional approach ya Access to Justice kwenye masuala ya msaada wa kisheria. Ndio maana unakuta tumefacilitate kwa kiasi kikubwa sana upatikanaji wa sheria, msaada wa kisheria ya 2017, lakini pia kwa sasa tuna network nchi nzima kwa kushirikiana na Wizara ya Sheria na Katiba ya wasaidizi wa msaada wa kisheria takriban 4,000. Kwa mawakili, mojawapo ya kazi ambayo tunaifanya ni kuhakikisha kuna kuwepo na upatikanaji wa haki nchini. Kwa hiyo hii ni kazi yetu. Tunahusika vipi na Legal Services Facility inaweza ikafanya vipi kazi na mawakili? Tumezungumza, hata presenter aliyepita amegusia changamoto mbalimbali, na nimeona hata bungeni kuna baadhi ya changamoto za upatikanaji wa haki zimeongelewa. Kwa mfano, sheria tunayoipigia kelele ya masuala ya utakatishaji wa fedha, ambao ni changamoto sana, inasababisha kwa kiasi kikubwa kukosekana kwa haki kwa wale ambao wanakuwa wanahusika na sheria hiyo moja kwa moja au kwa namna nyingine. Unaweza ukafanya kazi na sisi kwa sababu mojawapo ya kazi ambayo tunaifanya ni kutoa ruzuku kwa mashirika yasiyo ya kiserikali, lakini pia wadau mbalimbali, mawakili na entities nyingine ambazo zinafanya kazi katika upatikanaji wa haki. Lakini sasa hivi kuna sheria mpya ya arbitration pia, ni mojawapo ya initiative ya upatikanaji wa haki nje ya mfumo wa mahakama. Majaji, lakini mawakili na wasaidizi wa msaada wa kisheria tunataka tufanye nao kazi sana kuhakikisha haki inapatikana, sio lazima katika mfumo rasmi wa mahakama. Nashukuru sana na naomba kuwasilisha ofisi yetu iko pale Masaki, Chole Road. Tunaweza ukatutembelea au unaweza ukaleta andiko lako tukaona namna gani tunaweza tukasaidiana katika aidha kutoa ruzuku au kufanya partnership ya kuhakikisha kwamba haki inapatikana kwa wananchi wote. Asanteni kwa kunisikiliza.
Asante sana wakili Deo Bwile, na tunashukuru sana kwa support tunayoipata kutoka Legal Services Facility. Amekuwa ni mdau wa TLS kwa miaka mingi sana. Kwa naomba tuwapongeze kwa makofi mengine. Kuna mwenzetu mmoja ameangusha link yake hapa, engagement link, kwa hiyo kabla mambo hajaharibika huko anione nayo. Okay, sasa naomba niwakaribishe Ngolongolo Conservation for 5 minutes and then we will proceed with the deliberations here.
Habarini za mchana mabibi na mabwana. Habarini za mchana jamani. Au mmechoka? Napenda kutambua uwepo wa mwenyekiti wa chama cha TLS, viongozi waliopo hapa, wanachama, wageni waalikwa, mabibi na mabwana na viongozi wote. Kwa majina naomba nijitambulishe. Naitwa Joyce Mgaya, ni mtumishi kutoka Mamlaka ya Hifadhi ya Ngorongoro na niko pale kwa nafasi ya kaimu meneja upande wa mahusiano. Kipekee kabisa niseme nimefurahishwa sana na ujio wenu, na si mara ya kwanza tumeweza kukutana katika mji huu. Katika nyakati mbalimbali tumeweza kuwa tunawasiliana na viongozi na wachache mmeweza kufika, lakini nasimama mbele yenu tena kwa mara nyingine kuwakaribisha kuja kutembelea eneo la hifadhi ya Ngorongoro. Natambua kwamba mna ratiba ndefu na ngumu, lakini kwa sababu mmeweza kufika mpaka mlangoni, tusingependa mrudi bila kuja kututembelea. Hivyo basi nisingependa kuchukua muda mrefu. Tutaweka dawati letu, tumeshaandaa watumishi wetu kwa wale ambao watakuwa na nafasi. Tungetamani sana muweze kuja kutembelea eneo la hifadhi, muweze kujionea kwa wenyewe kile ambacho kila siku watu wanakisema au kile ambacho mnakuwa mnakisikia au kukiona katika vyombo vya habari mbalimbali. Kusema ukweli, ningeweza kutumia muda mrefu kuelezea upekee wa eneo la hifadhi ya Ngorongoro, lakini nisingependa kuchukua muda wenu. Nimeweza kuambatana na mdada machachari sana amekaa pale nyuma, naogopa kuja mbele yenu, lakini yeye ametoa ofa kabambe. Amesema kwa yote yule ambaye yuko tayari kuja kutembelea Ngorongoro kwa day trip, yuko tayari kutoa ofa ya $100,000, kila kitu included, usafiri, chakula, park fees, kila kitu. So mimi ningetamani kama mtakuwa na nafasi, kama ratiba itaruhusu, ninaomba sana mniunge dada yenu mkono, sio tu kwa sababu niko pale kama mtumishi, lakini tuunge mkono juhudi hizi za kuendeleza utalii wa ndani, lakini pia mje mrefresh, kwa sababu tunatambua kazi kubwa mnayofanya. Mambo mnayozungumza hapa ni mazito. Nimesikia tu kidogo hapa Mzee Hosea anazungumzia how you can contribute to the financial sector kama legal experts. Ni vitu vikubwa, so tungetamani mkimaliza kuongea mambo mazito basi njoeni hifadhini mpate kupumzika. Sinawezekana jamani? Kwa $100,000 ni kubwa au sio kubwa? Mimi naona ni nafuu. Kila kitu, chakula, park fees, transport back and forth. Kweli tunaomba mje mtuunge mkono. Tumechoka kukaa na wanyama peke yetu, tunachoka. So tukiwaona hivi, yani tumetoka mbugani. Mimi nasema ukweli, nilivyosikia kwamba ndugu zangu wako hapa, nitambuku mdogo wangu naye ni mwanasheria, si kwa nini hajaja. Nikamwambia kwa nini hujaja this time around? Akana sababu zake, lakini najua mmetoka maeneo mbalimbali ya nchi yetu, mengine ni mazuri kama ya hapa, lakini sio vibaya kuja kutuona jamani. So tutakuwa hapo nje kuanzia saa 9. Kwa wale ambao wako tayari kuja kututembelea, tutaweka utaratibu mzuri na isiwe mara moja. Naomba mchukue contact za huyu dada au hata za kwangu, naweza nikatoa namba yangu. Hata mkiwa na nafasi at a private level, tuko tayari kuwahudumia, tuko tayari kuwapokea, tuko tayari kuwatembeza ndani ya hifadhi. Kama mtaniruhusu, naomba nitoe namba yangu kwa uwazi kabisa, kwa sababu mimi ni mtumishi wa serikali.
Tuiandike.
Sina siri kwenye hilo.
Tuanze kuiandika.
Naomba lakini kwa mawasiliano ya kazi tu jamani.
Wewe umesema tayari.
Ilianguka sio ya kwangu, naomba ni declare interest. Sio ya kwangu. Namba yangu ni 0757 56 79 73. Naomba kuirudia, ni 0757 56 79 73.
Sema nimesikia wananong'ona, tukumbushe jina.
Joyce Mgaya. Kama kuna mtu anamfahamu Paulo Mgaya huko kwenye hizo shughuli zenu, basi yule ni mdogo wangu. Mimi ndio dada yake. Asanteni sana, karibuni tuonane hifadhini. Asanteni.
Sawa, nilikuwa namkumbusha Jumamosi kuanzia saa 12 asubuhi safari ndio inaanza kwenda Ngorongoro, ni mbali kidogo. Basi kabla sijarudisha kipaza sauti kwa mwenyekiti hapa, bado nawakumbusha social distance please. Bado na nafasi za kutosha pale juu. Tusingependa kuona watu wanabanana sana kwa taratibu ambazo tunajaribu kuepuka na hili janga tulilonalo. Kwa hiyo naomba nisitumie muda wako mwingi sana mwenyekiti, naomba uendelee. Asante sana.
Asante sana. Leo wakati mgeni rasmi anatoa hotuba yake, alituambia kwamba kuna mchakato wa kutengeneza sheria za Kiswahili. Maana yake zinatoka Kiingereza kwenda Kiswahili. Sasa jambo hilo likanikumbusha kwenye session moja ambapo mkalimani aliambiwa kumtafsiria mahabusu mbele ya hakimu. Hakimu akazungumza kwa Kiingereza. The accused will be remanded in custody until further notice. Mkalimani. Mshtakiwa utawekwa rumande mpaka baba yako atakapopata taarifa. Sasa yule mahabusu akasema, anamwambia mkalimani, baba yangu ni marehemu. Mkalimani badala ya kumrudia hakimu, yeye akasema basi mama yako. Thank you very much. Fursa hii kumkaribisha Mheshimiwa Jaji mstaafu Honorable Justice RTD Dr. Faust Twai, a retired judge of the High Court, senior advocate and member of Tanganyika Law Society, na mimi naongeza ni president wa Tanganyika Law Society. Karibu sana daktari.
Thank you, Chair and President, kwa mantiki hiyo ya mwisho. Niachane na protocol, lakini natambua uwepo wa rais wa TLS na marais wa staafu wa TLS hapa. Nimemwona rafiki yangu Charles Rachungura. Natambua uwepo wa Mheshimiwa Jaji Makaramba, mabalozi Mwanaidi Sinare, balozi Adadi nimemwona hapa, wanachama wengine wenzangu wa TLS. Ni dakika 10? Sawa.
Dakika 10 Mheshimiwa Jaji.
Nashukuru. Niende haraka kidogo, hasa katika ile eneo la mwanzo ambalo nimeona niliweke kwa kihistoria. Topic ambayo nilipewa ni emerging practical and ethical wakati wa Uhuru Declaration, post Uhuru, baada ya Arusha Declaration na mwaka 67. Baada ya pale, kama mnafahamu, siasa ya ujamaa kujitegemea ambayo ilikuwa inaleta a centralized economy. There were widespread nationalization of properties and business entities, etc. And in view of that, since the economy itself was centralized, it was also necessary for the government to centralize the system of training, and for lawyers impacted on the way that they were being trained, but also on the way that they were being recruited into employment. And that was that the majority of lawyers, almost all who graduated from the then University of Dar es Salaam, before then the University of East Africa, they were recruited as public lawyers to serve within the government and in public institutions. And the requirement was that you cannot be a private advocate until you have clocked 5 years in the public sector. And therefore, it was very difficult to find a young lawyer being admitted the moment one graduates from the university. Sasa, kwa sababu hiyo, even the survival of private practice was questioned. If you remember the Msekwa report, sometime in the 1970s, it recommended the abolishment of private practice. That was the situation, to the extent that private demand for private legal services. One thing that remained the same was high fees. Even the time that I graduated, the fees for legal practice, for legal services was very high. And somehow this assured the survival of private legal practice. It was very easy for any lawyer who wanted to join legal practice, and having gone through the qualifying process, to start practicing. Immediately you get clients. The market was there. The services were limited, and therefore survival wasn't a problem. During that time, even the requirement that you should have a business license was not there. This came in 1999, for those who do not know. 1999 or 98. Before then, you didn't have to have a business license. So long as you are admitted and you have the admission certificate and the practicing certificate, you can start your business and move on. In the past 2 decades or so, the landscape has changed considerably. There was a continued expansion of private practice, but still legal practitioners in the private sector were still very limited in number. There was an increase in the demand for legal services because of the expansion of the private sector, and therefore the fees remained high. But during that time, we also saw the emergence of specialization and the establishment of some law firms. There were very, very few, extremely few during that time. I remember when I was doing my research on the legal profession, there were about not more than 10 law firms in our country. But there was also greater gender balance. Before then, most of the lawyers in private practice were men. But during that time, during the past 2 decades or so, there has been an increase in gender balance with more and more women coming in. In fact, one of the, in some of the classes these days, you go into a class as a teacher and you find the majority are women and not men. So the balance has changed considerably. Then came the law school, and with the law school, a much faster expansion of private practitioners. You have now 600 lawyers being admitted in a single day. Before then, during my time, for instance, when I was admitted, we were only 12 of us. So that was about the number of advocates you would expect per year. Now you can imagine from 12, you now have 600 twice a year. And that's why we got to 10,000 lawyers on the roll.
3 minutes, my lord.
Oh, sorry. Let me go now to the dilemmas. What are the practical dilemmas and the ethical dilemmas? These are what I have on my list. Market saturation. While the market has expanded, the supply of legal services has also expanded. And as a result, you have more and more lawyers who are ready and capable of rendering legal services, but they don't have the opportunity to do so. We have lawyers today who are trying to get to make ends meet because they don't have sufficient opportunities to make a living from legal practice. There is therefore a decrease in real income for lawyers. There are the ones who are still flying well, but there are those who are suffering. I spoke once with a young man. He has about 10 years plus in practice, and he was having problems simply of paying his rent for his office, and even for paying for his practicing certificate at the end of the year. Now this is a problem. A 10-year experienced advocate not being able to pay for the rent of his office. Now, the other practical dilemma we have is the increase in technology. Social media and other platforms that are there have brought their own problems, and you know them. We have problems with state attorneys and legal officers, and this is one of the discussions that we've been having this morning. There are some lawyers who are working in very remote conditions. This may be a positive thing, because then there is a better distribution of legal services in the country, where you can find a lawyer in a village. There was a time when there was not a single lawyer in an entire region. When I did that research, Lindi had no lawyer. There was only one lawyer in Mtwara, one lawyer in Songea, and there were some other regions which did not have lawyers at all, Sumbawanga, etc. Now there is a good supply of legal services in remote areas, but they live in very poor living conditions, and sometimes it's difficult to raise to higher levels. So
my lord,
very many there.
Grant one additional minute to conclude.
Can I have two, please?
Granted. Strictly.
Okay, possible solutions in dealing with change Change is bound to occur, and therefore some of them are temporary, some of them are permanent. Find ways to face these challenges, face them with the view of solving them rather than running away from them or postponing them. Challenge your assumptions, try it and see whether there is a better way of doing things rather than the way that you are used to. Learn new skills, and here matters such as ICT, etc., come into mind. Ethical dilemmas. Some of these are the result of market saturation, things like undercutting. These are problems that were not there before, but today we hear of them. Some of us are overly ambitious with the desire to succeed. That have been made there that are not progressive are many. And you should also look at how matters could change for the better. The independence of the judiciary as well. The way our judiciary is has failed justice. One is the case involving debts, district executive directors, and the second one concerning the issue of